Go ahead and get started. I'll take a second here and introduce myself in case we have anybody else come in before we really get into the meat of the presentation. And everybody that's online, thank you so much for attending. I look forward to talking to you all. I'm Brooklyn Hagan. I will be presenting on maintaining your independence as you age. So we will talk about adult guardianship, durable powers of attorney, living wills, healthcare surrogates, and just kind of get a good overview of all of those topics. If you all run into any questions, feel free to ask them. And I will stop periodically throughout the presentation and ask if there are questions. If you all think of anything, you can just raise your hand and I'll be happy to stop and address things. So before we get started, just really quickly, a little bit about me. I know that there was a flyer that was sent out with a small biography on it, but my background I'm a third-year law student. I will be graduating in May and taking the bar in July, so thank you. Yeah, exciting stuff. I'm looking forward to it. So before I was a law student, I studied history and social studies. I was a middle school teacher for a few years. And then I came to law school. So I am thrilled to be here. I'm one of the student attorneys next door at the Traeger Elder Law Clinic. I've been here all spring with Professor Shaw. It's been great, just a wonderful experience and looking forward to talking to y'all a little bit more. So, all right, we will go ahead and get started. And this is going to be a real struggle for me because I'm a wanderer and I have to stay on camera. So we'll do our best here. All right, so it is not advancing.
Oh, please.
Okay.
I tested this.
Of course it didn't work now.
Of course not. No, it's, Murphy's Law with.
So what I'm going to do is I will, if you give me a little meaningful pause at the beginning, at the bottom of your slides, I will advance them for you. I apologize.
Oh, that's fine. All right. So just to start out, actually, if we could, oh, it just took off on me. Go back a couple of slides. That would be wonderful. One more. Okay, so we've got three objectives that we'll really deal with today. Kind of already mentioned these, but mainly we'll be talking about the differences between a guardianship and a durable power of attorney. So that's where the bulk of our time will be spent. We'll talk about having a durable power of attorney, the benefits that will provide to individuals as they age. And lastly, we will wrap up with some information about living wills and healthcare surrogacy and how that will help to preserve your wishes as you continue through life and make some medical decisions that you may not want your family to have to make, that sort of thing. So we will move on and start with adult guardianship. And the first question is basically, what is an adult guardian? So that is somebody that is appointed by the court and they will become a guardian for another adult individual. And the person that is in need of guardianship is called a ward. And this is really a pretty public process that you go through with guardianship. So to appoint a guardianship, this is really a court process. So a petition has to be filed with the court and evaluations are performed on the respondent or the person who may need a guardian. And again, this is a pretty involved procedure. It's done by a physician, a psychologist, a social worker. Various tests are performed and evaluations. Conversations are had, and then after those evaluations are performed, since this is a court process, that information gets filed with the court. And on top of that, a trial by jury is done to determine whether a guardianship is necessary. So if a guardianship is necessary, then the judge will make a decision and name a guardian. So again, just really to point out, this is an incredibly public process. Yes, sir.
So, just really quickly, you don't have to have a trial by jury, but you are entitled to a trial by jury.
Okay.
So the respondent is entitled to have a trial by jury. Generally speaking, though, if you're going to apply for guardianship over somebody who's a family member, a friend, a long-term paramour, and you're the person petitioning, you can work with the county attorney and waive that trial by jury and just have a bench trial.
Okay.
But if the potential warrant says, no, I do not want a guardian, they are entitled to have a trial by jury. And then at that point, the jury would make the disability determination.
Okay, thank you. So just a quick recap in case anybody online didn't hear that. My professor is here and he is helping me with some clarifications where we need them. So a trial by jury is an option. It's not a requirement. You can do a bench trial, which if you're not familiar with that, that's just the judge making the decision. And the ward will be the person that determines whether they want that trial by jury. If the person does not want a guardianship, then they can say, I want this trial by jury. Otherwise, that decision can be waived. All right, any questions so far? Okay, so really, who serves as a guardian is the next question that we can run into. And generally, this is family members or friends that will serve as guardians. Children, siblings, parents, if necessary, any family or friends that are willing and capable. So something that happens, though, is if there is nobody that is able or willing to serve as a guardian, then the court will appoint that guardian through the state. And that comes from Health and Family Services, is that correct?
Yeah, Adult Protective Services.
Okay.
For the Cabinet of Health and Family Services. Not generally speaking, we look toward the village that the
Okay.
person has. Who's available, who's qualified.
Mm-hmm.
There's a qualification process, there's a questionnaire they have to fill out. Anyone who's been convicted of a felony of moral turpitude probably should be a guardian. The judge probably wouldn't allow that.
Mm-hmm.
There's questions about bankruptcy. If somebody's currently in a bankruptcy, they're probably not going to serve. It's somebody who can serve both in a fiduciary capacity and has a relationship with the ward.
Okay, perfect. So just again to recap, primarily you do want to look to friends, family, that group of people, somebody that has a relationship with the ward to begin with. There is a qualification process that you would go through, and as a result, if you've got to have somebody that is able to, as we'll talk about in just a moment, deal with financial decisions, personal decisions, that sort of thing. So you want somebody that is qualified and able to make those decisions. So the court will look at that and make sure that that person is fit to be able to serve in those roles. Okay, so we can move on. So a guardian, as we kind of previewed there just a second ago, will assume control of decision-making for the ward. This involves financial decisions, personal decisions, like healthcare matters, that sort of thing. Any type of decision-making that is necessary, that guardian is there to do that. So I didn't really know how familiar my crowd would be, and I'm suspecting we'll be pretty familiar with the Britney Spears conservatorship. Okay, so that's what I thought about a lot when I thought about the guardian, is, you've got somebody that is making decisions for another person. Legally, they are that entity. So you have the guardianship of the person and of the estate, and that is, that's really a big process. That's a lot for somebody to have to deal with. And we can go ahead and advance. So a lot of people want to avoid this. You want to be able to kind of make this decision, take this decision into your own hands and determine who will serve for you, what they'll be able to do, that sort of thing. So the way that you can kind of take back this independence and really establish your own wishes without necessarily the court and a lot of outside parties getting involved is with a durable power of attorney. So we can move on here. And a durable power of attorney, again, it just allows for more personalized decision making, allows you to be more in power and in the driver's seat of your own decisions, which is something I think that we all want to be able to do. So a durable power of attorney is a document. And this is a document that allows an individual to determine, before there are any capacity issues, who will serve if as their agent should they become incapacitated. So again, this is a document that you can set up now while you are able and that sort of thing to be in place for later when you need it. So an agent is a person that acts really similarly to a guardian, a lot of the same roles and that sort of thing. And they are able to exercise power really in any way necessary to take care of personal and financial needs for the principal, the person that has created that document. So again, if we think about that, like, isn't that kind of just like a guardianship? And we can move on. And in some ways, yeah, but not so much. So a durable power of attorney does not require an assessment by multiple parties. Like I said, this is something that you can do now and have it prepared for later. It's primarily done out of court. That's something that can be done in a law office. You can establish that there, and it gives you personally more control of your situation. If, for example, I'll use somebody with multiple siblings as an example. Like if you have multiple siblings but no children and you want to go ahead and establish this document, you may have one sibling that you know will take care of all of your interests. All of your siblings love you, they care for you. But there's some people that you just don't want in charge of all of your decisions. I think we all can think of those kind of people. And in this situation, you can make the decision to choose who you think will represent your best interests, which is great. Now, a durable power of attorney may also be revoked by the principal. So if you create this document and circumstances change, and you no longer want the person that you have appointed as your agent to serve as your agent, then you can revoke that document. So like, for example, if you're married and your spouse is serving as your agent, something happens and you divorce and you don't want that person to serve as your agent anymore, you can revoke that document. Questions so far? Yes.
So let's say you have someone as your power of attorney,
Mhm.
and in the event they're not able to make decisions on your behalf, can you appoint like someone as secondary power of attorney?
Yes, absolutely. That is one thing that you can do if, as you're creating this document, if you don't want to have to revoke and do a new one, is have a clause in there that says, if somebody is unable to or unwilling to serve as your power of attorney, this is your secondary choice. So yeah, that is, yes, sir.
My question is about, so I work at a federally qualified health center, and a lot of the times, a lot of people come to me and they ask for medical powers of attorney.
Uh-huh.
A lot of the times, those medical powers of attorney are done as for some of the medical decisions for someone who's like older and not as mentally present as they were normally. I'm wondering what incapacitated means in respect to when this would come into effect in someone's life, because it's pretty easy to tell when that's the case medically, because they're already like, with the doctors talking about, either be like dementia or some other situation medically that's causing them to not be as mentally present. So I'm just wondering what does incapacitated mean?
Sure. Professor Shaw, I'm gonna let you take that one, if that is okay.
That one's really complicated.
That's exactly what I was
That's
thinking.
a hard question. So incapacitated, so there's two different kinds of powers of attorney.
Can you just reframe the question, just?
Oh, sure. Absolutely. So the question, if I understand, is how do you know when the person who was the principal on the medical power of attorney has reached the point of incapacity so that the medical power of attorney becomes an effective document in order to allow the decision maker, the person that's been named as the power of attorney, to make decisions on behalf of the incapacitated person? Is that the question?
Yeah, and also make sure we talk about that for the same for the durable power of attorney as well.
Sure.
I want to know both for sure.
Sure. So there's two different kinds of durable powers of attorney, durable medical or durable general power of attorney. One's a springing and the other one's a non-springing. And typically what I tell people when we draft a power of attorney is to make a power of attorney that's a durable general or durable medical power of attorney that isn't springing. That means there's no condition precedent. So that power of attorney is in effect immediately, and it doesn't require the person to be incapacitated. So the healthcare provider can rely on that document without making a capacity determination. The other form of power of attorney is a springing power of attorney, and that power of attorney only goes into effect at the point of incapacity. Incapacity in Kentucky is generally determined, well, can only legally be determined by three different people: any judge, any attorney, and any physician. And a physician also includes a PA or a nurse practitioner. So generally within the springing power of attorney, there'll be a definition outlined as to what's meant by incapacity. The majority of the ones that I've seen in practice say, in the opinion of two or more physicians, the person lacks the capacity to make decisions in their own best interest. So that springing power can be any definition you want, but the statutory definition says it has to be either a judge, an attorney, or one physician. So then the question comes up, hey, if I just grant power of attorney to somebody and it doesn't have a condition precedent or it's not springing, what's to stop that person from making decisions when I have the ability to make decisions for myself? So that sometimes is a concern. And what I'll tell people too is, so if you grant that power of attorney, they can't act on your behalf without the document. So go ahead and grant it and hold on to the document. And when you need them to make decisions for you, then give them the document, because they can't act without the document. It's a good question. It's a complicated question. Did I answer your question?
Yeah, thank you.
All right, perfect, great.
And kind of to tie that back into the independence part of this presentation, if you have that document and you wait to give the document and grant that, again, that gives you some independence. When you determine that you need help, you're able to do that, so.
I'm so sorry, one question I just thought of, that's okay.
Yes.
I think it makes sense. And just so I get this clear, so a springing and non-springing power of attorney is determined upon its like conception.
Yes.
So what I'm trying to say is, so not every single medical power of attorney is springing and not every single non-durable one is, not every single durable general one is non-springing. It's just based upon what is agreed on.
What's in the document, right? So durable just means that the power of attorney is going to last past the point of incapacity.
Okay.
So power of attorney is kind of the most generic form. Durable means it's going to last past incapacity and it'll end at death or revocation. And then springing means there's a condition precedent. So those are all kind of like just add-ons to the power of attorney. The idea is we want people to maintain as much independence as possible. We're really pushing in guardianships across the United States in general to kind of move away from them as much as we can, because we're looking for the least restrictive environment for people. People need to maintain their independence and freedom. In a guardianship situation, people lose their rights. So they've been labeled or they've been determined or adjudicated to be a disabled person. And depending on the jurisdiction, it's either an incapacitated or a disabled person. They're not allowed to enter into contracts anymore. Sometimes they're not they're not allowed to maintain the right to vote. Sometimes they're not allowed to maintain the right to drive. And that all happens in that disability determination part of the guardianship hearing. So it really is important to address these things beforehand if you're going to maintain your independence as an adult as much as you can. Good questions.
Any others? All right, and then, of course, anybody online, if you all have questions, just feel free to drop them in the chat, and we're monitoring that, so. All right, so just kind of a recap here on the differences between the two. So establishment is one of the main differences. A durable power of attorney is established by a document, and that is established, while you still have capacity to do so. And a guardianship is created by court. So that is when capacity issues have already arisen and you're addressing it retroactively. So really the durable power of attorney is more of a proactive document, like I'm young, I'm able to make these decisions, I know what I want to do as I'm getting older, and I'm gonna lay it out in this document, that kind of thing. The public versus private aspect is another primary difference between the two. Again, a durable power of attorney is established privately. It's a document. You have that conversation with yourself, the person creating the document, perhaps the loved ones that are going to be serving as your agent when that time comes. Much more private, quiet affair. Again, guardianship requires a determination by the court. That can be a bench trial, trial with a judge and jury. That can get pretty public. So as far as revocation, that's another area that is different. Power of attorney can be revoked by the principal. The person that establishes the power of attorney can revoke the power of attorney if they so choose to. Guardianship, revocation, again, is not the same thing. You can't really revoke that. That has to be a court determination. Again, my mind goes back to Britney Spears and her whole ordeal from a few years ago. Lastly, the principal may choose who serves as their agent in a durable power of attorney. You have the choice to choose your primary, secondary, tertiary, should you find that need to be. A guardian is appointed by the court. It's determined perhaps without the principal or the ward's assistance or input.
So there is still input from the ward.
Okay.
It's through the guardian ad litem.
Okay.
The ward has an attorney assigned to them as a guardian ad litem to speak.
Okay, thank you. So you do have some input, but it's through your guardian ad litem, the attorney that's assigned to speak for you with the court. So you don't really choose so much on the front end. Questions about any of these key differences? Okay, so we'll go ahead and move on to, durable power of attorney sounds great. How do I get one? An attorney can help with this document. So this is one of the documents that we draft over in the elder law clinic. Just to kind of give you an idea there, it is exactly what we talked about. You talk with the attorney, determine who you want to serve, that sort of thing. Questions about durable power of attorney? Yes.
So, again, I work at Frederick Public Health Center. A lot of our patients are uninsured, poor income, and overall probably cannot afford an attorney. Are there any other entities that could probably do one that could be covered by like insurance, for example? Or I'm just trying to find situations where someone might want to I'm just trying to find solutions to if someone wants to do a durable power of attorney, but they can't afford an attorney, and what their options are.
Okay. So option is the elder law clinic. We draft those documents here. So we draft for low-income individuals that can't afford an attorney. Documents are done by student attorneys, so that's something to consider. Anything else that I need to add with that, Professor Shaw?
All sorts of other options. So there's forms they can get online. Certainly, if you're in a pinch, you can download something from the internet. I'd read over it very, very carefully. Absolutely anybody that is indigent in Jefferson County is welcome to come to the clinic. They don't have to be a patient at Traeger. The clinic is overseen by the law school. So they're really, I mean, that's a great resource. Legal Aid Society is another place that would be a resource in Southern Indiana. Indiana Legal Services is a resource that can provide those powers of attorney. You can even go online to the Indiana Legal Services website if you're an Indiana resident and fill out a questionnaire and just print that power of attorney from the Indiana Legal Services website. Sometimes you can get a medical power of attorney through the VA. If you're a veteran, you could probably also get a durable general power of attorney through the VA if you're a veteran as well. Those do have to be notarized or they're not good outside of the VA. If they don't have to be notarized to be good within the federal construct though.
So just to recap, for those online, lots of resources, in addition to the Elder Law Clinic here, which will serve anybody in Jefferson County. You don't have to be a patient here at the clinic. Legal aid here in Louisville is an option. If you're an Indiana resident, Indiana Legal Services. There's some online options if you're in a pinch, but be very careful with those. Read over them, that sort of thing. Just be very aware of what you're signing and what you're doing. All right. So moving on then to other ways to protect your choices and your decisions as you age. So a living will is a great option. So again, the next question is primarily, what is a living will? And several years ago, before I got into this field, I went to a doctor's appointment and they asked me, they said, do you have a living will? And I was like, no, I don't. That's probably something I should consider. What is it exactly? And so, you know, what is a living will? Often it's called an advance directive. You may hear those two things interchangeably. And essentially, this allows you to create a document to tell others, your medical professionals, family, friends, your medical wishes at the time of your last illness. So this is different than a do not resuscitate order or a DNR. So a DNR is a medical document. Living will is a legal document. And a DNR is basically the document that says, if your heart stops, you don't want assistance from doctors to resuscitate you. Again, different than a living will. An advance directive or a living will is a much broader document. Questions so far before we get into the meat of a living will?
So also the living will is more of a liability waiver.
Okay.
So what the living will is saying is, these are my wishes, and I'm directing the doctor, the medical provider, the hospital, and letting them know that if they allow natural death, I'm not going to sue them. My state can't sue them. I'm releasing them of that liability.
Okay. So just again, a really quick recap there. It's kind of a liability waiver as well for doctors. So that will help you to release them from liability, that if they allow natural death, you will not sue them, your estate will not sue them, that sort of thing. Yes?
What question I have is, what is the best document to use? I'm assuming a living will, you can put parameters on it, so under certain conditions, I don't want to be, I don't want any extreme care, you know, brain dead, that kind of thing, should, in an accident. So how do you best, it's not, for me, it would not be all or nothing. So how do you convey that?
So
There's a statutory living will document, and you initial by what you want on that statutory document in Kentucky. So there's really predefined things that you can say, yes, if this is the event. So generally speaking, when you think about a living will, we think about in the event that I'm terminally ill and permanently unconscious, And in the opinion of 2 or more doctors, I am not medically likely to regain consciousness. These are my wishes. Mhm. Great question. Did you have a question?
I was just gonna say, like, basically there are kind of 3 general categories in a living will. It's like full measures, limited measures, comfort measures only. And then you can allow your surrogate to make the decision. So like, for example, I've had this conversation with my wife, and if my heart stops and I have just a heart attack, please, try to resuscitate me. And if I fall out of a 3-story building, I'm giving you power to basically make decisions about the type of care you want me to receive, because they're totally different types of circumstances, and you can it has that flexibility.
Yep, absolutely. Yeah, and there's even subcategories in those categories as well. And there's many documents. The living will is just one of them. And it only works for terminally ill, permanently unconscious, and unlikely to gain reconsciousness within medical probability. Then there's another, but it only works in the hospital. So there's another document that you have to have for the ambulance, and it has to be on hot pink paper.
So that's been up to, okay, so I don't want to get in the weeds about the MOST form, but if you want to talk, I coordinate the State MOST Coalition, so we can talk about that a little bit.
Okay.
But is there a better time to talk about the MOST form?
Probably on a different presentation, because I think you've got quite a bit to get through still.
Yeah, I've still got a little bit here to kind of get through the creation of a living will.
Yeah, what I'm just trying to say is it's very limited circumstances for your living will. It has to be in a medical facility. It cannot be in the ambulance.
So let's go ahead and jump into how to create a living will, and then we will go from there. So again, always a good decision to discuss your wishes with your loved ones. So going into everything, the people that, should you end up in the hospital, are going to be there with you, know what's going on. This is a document that can be created with an attorney, but as we've already discussed, Kentucky has this document available online for you to fill out. So it's not always necessary. You can fill one of those out yourself and get it notarized, and it's good.
Interesting tidbit. There's a town, I think it's in Michigan or Wisconsin, where 97% of the residents of the town already have a living will. It's like the big thing in the town. Anybody moves in, they're knocking on the door, getting them to fill out their living wills and take them and file them at the hospital.
That's good to know. So yeah, this one, it just really kind of dictates whether you would like to receive medical treatment and artificial nutrition to prolong your life in this state that we've talked about. If 2 or more doctors determine that you are permanently unconscious, unlikely to regain consciousness, or you can allow doctors to provide comfort care, keep you comfortable, not in pain, and just allow for a natural death. This document, you can also indicate whether or not you would like to donate your organs, switch organs, that sort of thing, and you can allow others to make these decisions for you if you would like. I know that for a lot of people, the idea of having to make these decisions for loved ones is really tough. And there's just a certain kind of concern there that you're thinking, like, is the decision that I'm making the decision that this person would want me to make? People think about, like, do I want to make my family make these decisions on my behalf and go through all of that? So this really, if you talk about this with your loved ones and kind of everybody gets on the same page, it's all there. Additionally, if you don't have anybody to make these decisions for you, or you don't have anybody to talk to about these decisions, this is a document that you can create to where these decisions are already made and they're on file, and should something happen, then the doctors have that. All right, so if we can go ahead and move on. Again, it will be used if you are permanently incapacitated. You're able to communicate. If you're able to communicate with your doctors about your wishes, you have the capacity to do that, then it's not going to be used. It's just kind of there in case. So next thing is, who needs to be aware of your living will, if we want to go ahead and move on. Again, recommended to have it on file with your primary doctor, recommended to have it on file with, if there's a hospital that you typically use. All of those are good places to have that. You can upload it into MyChart. It's available. MyChart's kind of cool. I know that I'm talking about this to the healthcare profession, but I just think it's really neat that MyChart communicates with so many different groups. But again, you know, if you've got different places that you go, it's good to have that on file because some things transfer, some things don't. But I think that's really cool when I go to the doctor and they're like, yeah, we've got these changes. And I'm like, oh, I haven't talked to you about that because I haven't seen you in a year. But anyway, so doctors, hospitals, again, recommended to make your loved ones aware of this. That way they kind of know. And if there are any questions or issues, they've got that. So
It's important to use the statutory form whenever you can, though, because the statutory form has the magic words. They're difficult to enact, but they're easy to revoke. So a living will can be revoked orally. So it doesn't have to be in writing, it can be orally. So the patient has a living will, the doctor's trying to implement the living will because you meet criteria, and the patient goes, no, wait, I changed my mind. That's the end of the living will. It's revoked.
So important to know that as well. Just for those of you online, if you didn't hear, living wills can be revoked orally. If somebody says, no, I've changed my mind to their doctor, then that's the end of it. So how to create, we've kind of already talked about a lot of this. Yeah, we've actually already talked about a whole lot of this. I think I got myself jumbled up here a little bit. So yeah, we can go ahead and move on. So what about if you want to change or get rid of your living will? We've kind of touched on that just a little bit. It can be altered or revoked. You can revoke it in writing. You can revoke it orally. Yeah, you can change it any way that you would like, and that goes into effect at that point. Questions? No questions? Okay. All right, well, so if there are no questions, then I think that, yes.
So what we really talked about was maintaining this idea of maintaining independence, right? So that's important. Everybody has the right to self-actualization. So, you know, any opportunity that you have to refer anybody over to the clinic, that would be great. We're happy to help with this. It's really important, you know, not just to us individually, but, you know, to the judiciary throughout the country right now. There's a big push to help people maintain their independence. The court does not want to be involved in making decisions about people's finances, about people's healthcare, when there's other people that are available. So the sooner that people can get in to get these done, the better. Again, there's a lot of procedural safeguards that are in place. If you've named somebody to be your power of attorney that was your spouse and you get divorced, that person is no longer your power of attorney. It immediately ends. So you can then reappoint them, but it immediately ends. Yes.
Good question about the, it's called Elder Law Clinic. Do you have any flyers or business cards regarding like lists of services and ways to contact you all?
So we're on the website. So on the Traeger website, it lists what the Elder Law Clinic offered this year. So what we offered this year was the durable general power of attorney, the medical power of attorney, the advanced directive, and a basic will. I'm doing a little bit of redesign for the fall, so I'm not sure what we're gonna offer in the fall yet.
Well, I was only asking because I have patients who would like to give out handouts to people who have more questions, want to like find out about it later, so I was just wondering if you had any of those I could make copies of, but if not, that's okay, I can.
So I think we do have flyers.
But if you want to make some changes, and for the summertime, I know we need to discuss, during the summertime, while students are out on break, we will not have a full, you know, elder law clinic, so we'll want to change that messaging too. We want to make sure that people know that, so that they're not
We'll be
waiting.
back in September.
Unless you think, Lee, we should wait until.
Oh, no, we're gonna at least offer what we're offering now.
Okay.
Right, yeah. So we're gonna at least offer what we're offering now. I'm toying around with some other things.
Any other questions? So yeah, like Professor Shaw said, we really want to be able to help people maintain their independence, make these decisions. And these kind of decisions obviously are very life-altering decisions. And when you're dealing with that, I always, my thoughts are it's always better to kind of take care of that on the front end when you are able to really think about that and process the decisions that you're making and what you're doing and various implications of those decisions and all of that. That way, when the time comes, you've already got all of your ducks in a row, everything is set up, you just have to follow the paperwork. You just have to follow your decisions that you've already made. I'm a planner, I like to have things settled, so it's always good to deal with this sort of thing proactively. Yes,
So there is a question in the chat.
certainly.
Are there any specific legal requirements or considerations for different jurisdictions? Is that if there was a catastrophic accident that left the person incapacitated while they were out of the state or country, would these documents, power of attorney, living will, et cetera, be valid?
As far as the advance directive, I would think that since we're dealing with Kentucky statutory, and I'm gonna confirm my thinking here, that those documents would just be good for here in Kentucky. Now, the other documents, like a simple will, I would imagine that would,
So yes, the documents do go between jurisdictions.
okay.
Well, and I'll speak about the living will and the most form. So there's the medical order for scope of treatment forms. There's the spirit of the law and there's the letter of the law. And I have never heard a healthcare provider tell me they would not honor a living will or a medical order for scope of treatment as long as it didn't conflict with existing state laws. So for example, here in the Kentucky, our laws are fairly conservative versus a state like Oregon. So if someone came in with a form that was more liberal in terms of what they were allowed to dictate, that would change. But every provider I've ever heard has said they would honor it. But also, if you're traveling a lot and you have a terminal illness, you should have a document for every state just to be sure, which is kind of in terms of the living will or the medical order piece.
Yeah, so the powers of attorney, there's a Uniform Power of Attorney Act. And the Uniform Law Acts are, states can choose to be signatories on those, the uniform laws or not. The vast majority of the states, I think all except South Dakota, are signatories on the Uniform Power of Attorney Act. So your powers of attorney are going to be able to go from state to state. And generally, there's verbiage in the power of attorney that also says that it's if any of the elements in the power of attorney are unenforceable in a specific jurisdiction, that element falls out and the remainder of the power of attorney stays in effect. Specifically, the states like you're talking about, like Oregon and New Jersey, that have right to die legislation, like DC, the legislation exists and specifically states that you have to be a resident or of that state in order for that right to die legislation to apply to you. So if you have right to die in New Jersey and you're traveling into Iowa, obviously Iowa is not going to allow you to do that where New Jersey would. But if you're going from Iowa into New Jersey, you can't take advantage of the right to die legislation that New Jersey has because you're not a resident of New Jersey.
Thank you.
So on the flyers, I've just noted that we're on break between May and August over 2024.
Perfect. Yeah, we'll be back here. School starts back in the middle of August. We'll be back doing clinic hours beginning of September.
Anything else from the chat? Okay, anything else from the crowd? All right, well, thank you all so much for being here. It has been wonderful to talk to you all. And if there are any other questions, I'll be around for a bit, but if not, I think that's all I had. So thank you all.
Thank you.
Good job, Brooke. Good job.